Slater Crusaders, America's the greatest country in the world. Thanks for being here. Welcome to our special high court drama. We're going to talk to a professor about the history of borking and how these hearings have gotten so contentious for political reasons, and also how Barrett has done a perfect job this week. Just so much smarter than these senators. We're going to talk about Roe v. Wade from a legal, constitutional point of view, because that's what all of this is based on. All of this is based on Roe v. Wade and the left's love of it and fear that it may be overturned. So we'll talk about how it could be maybe overturned, what that could look like. Sometimes the left will say Roe v. Wade. Most of the time they just say health care. That means abortion. Now, sometimes they pretend that this is all about something else. It's not. It's all about Roe v. Wade. So we'll talk about that. And then we'll talk about the history of election year appointments. There's nothing unique about this moment in history with the campaign right around the corner. Alas, all that being said, we are living in a very strange, generally, moment. Maybe a turning point moment. We could go either way from here. And the only way that we can turn back to sanity is if we're all aware of what's going on and we just say enough already. I don't think we're going to do that. So it's going to get way worse. I want to talk about just in this week of the Barrett hearings, 3 very troubling things that have happened. The first, sexual preference. So Amy Barrett during the hearings said, I've never discriminated on the basis of sexual preference, and I would not discriminate on the basis of sexual preference. Some activists, which sounds great, like that sounds like the thing you're supposed to say, right? But some activists on Twitter said that that was offensive, the term sexual preference, because that suggests that who you feel attracted to is a choice, merely a preference, and that's not true. You're born that way, right? So someone on Twitter said that. The Democrats joined in on that attack. Then the media joined in. And then Webster's dictionary changed the definition of the word preference. They now call it an offensive term. Like that, to see the dictionary change in just a matter of hours was the first thing that happened this week. Second, the term court packing. Court packing means increasing the number of justices on a court. All right, so there's 9 Supreme Court justices. Court packing would be like adding 3 or 5 or 9 more justices, right? That's court packing. That's the definition. Overnight, the Democrats and the media together changed the definition of court packing to simply mean filling vacancies that already exist on the court. And they did that so that the Democrats and the media can accuse Republicans of court packing. This is an amazing tactic that no way could it possibly work if the media didn't play along to trick people. All right, so now the Democrats can say, oh, stop asking us about if we're going to pack the court. The Republicans have been packing the court for 4 years. What? Trump hasn't packed the court. Trump's filled vacancies on the court, but that's not court packing. And then the Democrats and the media call their actual court packing depoliticizing the court. That's all they're doing. They're simply depoliticizing. Vote Democrats, we will depoliticize the court by adding more justices to it, i.e. court packing. Amazing spin. And it wouldn't work if it, again, weren't for the media and if also it weren't for people's ignorance, just generally, which is one reason why I'm so glad you're here. And then the third, the worst of all, which is still unfolding as we speak, the New York Post story on Hunter Biden. You know this now, like Twitter and Facebook, they won't even let you share it. Twitter, so the House Judiciary Committee says, hey, Twitter won't let us share the link. So here's a link to our website where we have the story. And Twitter, when you click that link to the House Judiciary website, Twitter has a warning that says going to this link may be spammy. That's the term, spammy. And warning you that it can cause harm if you go to this external link or whatever. It's amazing. The fact that they wouldn't even let you share a New York Post story. And they came up with some BS excuse that oh, well, Twitter, we've had this rule since 2018. I think we have the tweet here, actually, guys. This is from Twitter. Yeah, there it is. That we won't allow people to distribute content obtained without authorization. Nonsense. Let's just say someone illegally found Trump's tax returns without his authorization. Would Twitter allow that newspaper and other people to share that newspaper story about it? Of course they would. That's what happened with the New York Times. We have no idea how those were obtained. Surely it was illegally obtained. How about the story a couple days before that, where one of Melania's so-called friends illegally recorded her and phone conversations and released those secret tapes so that she could promote her own book. What a horrible person. That was obtained without authorization. I mean, those are just two stories that Twitter allowed this last week. But this now is justified, the not being able to share this story, because it may cause harm? Yeah, to Biden. I sure bet Kavanaugh wished this standard existed during his hearings. Would have saved him a lot of trouble. And the truth of all that is, those Hunter Biden emails and pictures, they were legally obtained. Apparently, Hunter dropped off his laptops for repair at a computer repair shop, never picked them up, left them there for 90 days. It says very clearly in the contract that if you leave it there for 90 days, it becomes the legal property of the repair shop. So it is legal, they were legally obtained. But you wouldn't know that from Twitter because it's described as a hack. Listen, I share those three stories from this week, just to know what we're up against and where we're clearly headed as a country. Maybe a bit of gratitude and peace can come from the fact that Amy Barrett is going to be on the Supreme Court. So let's talk more about that coming up. We'll talk about the history of borking next on our special High Court drama. Mike Slater, spread the word. You know how this works, right? You know investment 101, and that is to diversify. And you need at least some of your investments in something that is safe. And there's nothing more safe than gold. What could possibly be more safe than the thing that we've fought wars over and explored the world to find than gold? And now all you have to do is call Patriot Gold Group and they'll drop it off at your door. You can have it forever in your possession. That's the most important thing. It's yours. Right now it's around $1,800. Bank of America is thinking it's going to go up to $3,000, and everywhere else in between, different banks, different advisors. The more chaos there is, the higher it goes. And I don't know about you, but I am foreseeing some turmoil to come. Throw on top of that inflation, $1 trillion stimulus packages. We're printing money. Can't print more gold. All the gold in the world, if you melted it down, it would fit into a tennis court, which is not big, a little tennis court, less than 10 meters high. That's it. That's all the gold that exists. And you can get some of it. It seems like an impossible thing. Like no way I can get gold. Yeah, you can. Just call them up, Patriot Gold Group. These are my guys. No commission or fees when you sell, which is awesome on top of that as well. They're America's highest rated precious investment firm by Consumer Affairs. 1-800-798-4260. Just got a few days till the election. Things are only gonna get worse. Get that gold in your hands. Also ask about a no fees for life IRA when you're there. 1-800-798-4260. It's Patriot Gold Group. Hey, Slater Crusaders, welcome back to our special. I remember when Barrett was first nominated, I thought, geez, what are the Democrats gonna do to attack her? She's unassailable. And I just went back to my very limited recollection, I don't have any recollection personally, but knowledge of borking and what was done to Clarence Thomas as well. And I wanna get some more insight about that with Adam Carrington. He's a professor at Hillsdale College, one of our favorite guests. Professor, how are you, sir?
I'm doing well. Hope you're all well. So hope you're all well too. Sorry about that.
There it is. We are. No, Barrett's more articulate than that. Thank goodness. Yeah. Borking. Was that the first time these hearings went horribly off the rails?
At least on television, which was a big part of it. And that's where the phrase borking came to be. And I think that the television made it worse. Now, certainly there have been hearings in the past that went badly, that even torpedoed or at least severely hurt a nominee's ability to get on the court, that made the Senate, so push back on that. But in general, this was the first time the acrimony, the contentiousness was laid out for everyone on national television, and I think that really changed everything.
What was Bork's role in it? Like, was he like that much of a? I mean, I read Slouch and Nakamura, right? He didn't seem like that crazy of a person, right? Was he like a total nut? Was it worth any of this attack on him, or was it purely political and grandstanding?
I think that he didn't, since it was the first time something like this had happened, he really didn't know what the best answer was for the public. He was very much an intellectual, someone who had taught at prestigious law schools, who had written extensively, and as an academic had been somewhat controversial. He'd been willing to go out on limbs on things like what he thought about the 1964 Civil Rights Act, or what he thought about some other controversial issues. And before, when just the senators were talking with a nominee, that could hurt, but it didn't cause sort of a national scandal, or couldn't be drummed up to that. And by it being on national television, people who opposed him were able to do a lot more with it, taking issues possibly out of context, pushing things. And I think he was, instead of trying to play to the voters that were supporting or not supporting the senators, he got combative, he got at times dismissive. And I don't think that should really have touched upon his own qualifications, but it looked bad, and by looking bad, really helped his enemies do more with his answers than I think could have been done otherwise.
Yeah, that makes perfect sense. So he didn't play the game, this new game that we've developed over all these decades now. He didn't play it right. Interesting. How much of a role did Joe Biden play in all of that? I hear a lot, but was he like the ringleader of it all, or no?
Ted Kennedy, for those who remember Senator Kennedy from Massachusetts, was really the ringleader that pushed it. Actually, Joe Biden seemed at first more open to his nomination, and only later came around. Now, he had a exchange with Professor and Judge Bork that was seen later as very damaging to Bork's nomination prospects. But I would say that from the beginning, Senator Kennedy was really the ringleader for this, which is interesting because the both of them were really ringleaders in how to respond to this from the other side. The person that really led and perfected the response to Borking was Ruth Bader Ginsburg, who just recently passed away, and who we're currently debating who to replace her with, which was to not argue, to basically dodge, to not really talk about specific cases and things like that. But that was really a response to what happened when Bork tried to argue back, and was in some ways where the Democrats saw what they had done to Bork and said, how can we avoid the other side doing that to us?
Yeah, so this is where I would argue that this is part of the game, and this is why the game doesn't serve us well, because wouldn't the public be better served if there was some actual, quote unquote, arguing, debating going on? But now there's no room for that. Now it's all about dodging everything, right? Yeah,
it goes both ways for both sides, because, and part of this is having TV there. And by the way, TV makes for more transparency in a certain way. But the negative sort of collateral damage of that is senators will grandstand instead of really trying to figure out what this judge thinks about particular questions of law or the Constitution. They'll basically try to create viral clips for the reelection campaigns. And on the other side, because of what happened to Bork, the judges now will tend to dodge, avoid, have canned answers, talk in generalities. And I think that can be problematic too, in trying to figure out, is this person that's going to be qualified or not?
Yeah, totally. What is about, how did the Clarence Thomas hearings relate to this, right? Relate to Borking?
I think that the Clarence Thomas hearings took Borking to another level, because a lot of the attacks on Bork were first professional about his opinions, about things he had written, and only secondarily became personal by saying, you wrote this article, you must therefore be this kind of bad person. With Thomas, the accusations went to, you have been accused, for those who remember the Anita Hill accusations, of privately saying certain disreputable or bad things, and therefore you are, as a human being, unqualified to do this. By the way, we've never been able to really substantiate those claims. It was very much a he said, she said at the hearings, but that became very personal. You're a bad human being because of things that actually aren't directly related to your job. And I think that's where the borking became really totalized, where anything, not just professional, but private, becomes on the table as an attempt to try to shoot down a nominee that you don't want to go through.
Now, Clarence Thomas stood up for himself, as did Kavanaugh. What ultimately happened with Bork? Like, why did he not? Why did that not get voted through? And Clarence Thomas did.
Yeah, that's a good question. I think one, while they all defended themselves, I think that Bork did so in a way that really turned off voters, turned off senators across the aisle, and in a way that I think was he came across as a condescending law professor, is how a lot of people described it. I think that Thomas and Kavanaugh realized better than he did that they were on camera. Thomas called it when he in his hearings a high-tech lynching. That really appealed to the voters that said maybe this guy is not being given a fair shake. Kavanaugh, similarly, when he defended himself, I think really made an appeal to the American people and thereby to the senators in a way that I think recognized how cameras had changed the circumstances in a way that I think Bork still did not, because he had not really had he became the example that the others, I think, had to react to.
We talked about this the other day in passing, because I was going through like how there's been 29 vacancies in election years, and every time the president's nominated someone, and we went through all those numbers, and it was super confusing. But there were two cases where one party held the White House and the Senate in an election year vacancy, and they did not get passed. And one was George Washington, and there was some like political, it was like the guy who he nominated like voted on something related to the Supreme Court. So Washington was like, oh, I want to pass or something until the next election. Anyway, right, so that's it. See, there you go. See, there's the president's like, oh yeah, you're talking about.
Yeah, it was the Jay Treaty that was very controversial, and there's questions about if it would come up before the court. Yes.
So what was it? Give me more details on that real quick. What was it?
So, and also, the Jay Treaty was negotiated with England because we were fighting with them after the Revolutionary War about shipping lanes and other issues related to occupying the same space, basically, in the Western Hemisphere, and and it was very unpopular. One of the least popular things Washington had done, I think, because we thought we could get a better deal from England, which I think was a little hard given how powerful England was related to us. And also they knew that a lot of those questions about the Jay Treaty might become before the Supreme Court. So both for political unpopularity and for questions of, is this guy going to adjudicate this case well? The person was dropped, and he was the first one for that to be done in the history of America. Yeah.
So that justice voted on the Jay Treaty, voted for it, and
was in another office, and was therefore considered someone that was the well had been sort of poisoned. That's where justices will try to say, I'm not going to comment on a case that might come before me before it does, because then it might give off the impression I've made up my mind before the case comes. That's actually a reasonable worry.
Sure. Why didn't he just like recuse himself? I wonder why Washington said we're not even going to nominate him.
I think that's where the political side came in. The Jay Treaty was also very unpopular, and I think he read the tea leaves that it would be better to sort of cut your losses and find another nominee that he knew would get through.
Wow. No kidding. Okay, so then the other person was LBJ's. Do you remember why LBJ's nominee did not get voted through or got denied by his own party?
Yes. Basically, from what I've read, and that's one I got to admit to being not as deeply familiar with, but basically it became a disaster in interactions with the senators. Actually, a thing it might be comparable to a little bit is when President Bush nominated Harriet Miers to the Supreme Court. I don't know if people remember this. Later, Samuel Alito was, and she pulled her nomination out. But there were some basic questions. No one should question her basic intelligence, but whether in conversations she was having with senators, if she was really prepared for the job. And I think there was some similar issues of that, plus some scandals and things that made the LBJ instance happen as well. And LBJ was kind of a lame duck by 1968. He wasn't going to run for re-election pretty quickly, and so the problems that LBJ was having himself within the party played into that as well.
The Harry Meyer thing happened before I was like really paying attention to politics, but I like vaguely remember how weird that was. Right? He nominated her and everyone was like, what?
Yeah, and I think, again, she was an accomplished human being. I have no doubt that she was a thoughtful person, is a thoughtful person. Sure. But mainly, as far as doing the job of judge, what was at least leaking out at that time was her private conversations with senators were causing some issues there. Similarly, another example of that happened in 1811 when James Madison was trying to nominate someone that he was partial to, and the meetings with senators, the lack of judicial experience made them say, okay, we don't think that this can happen. So there are instances where actual ability to do the job is actually a reason where candidates suffer or aren't able to get through. That's less and less now because presidents have seen it happen, and they're much more careful, I think, to make sure it doesn't. But yeah, it's happened in American history.
And to his credit, Trump's done a pretty superb job with his three choices. Adam Carrington, the one guy I certainly know who I can be like, remember that vague thing that kind of happened in 1778 or something? And he's like, oh yeah, Jay Treaty, bum, 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 bum. Adam Carrington from Hillsdale College. Thanks, Adam. Appreciate you.
Always a pleasure. Thank you.
Thanks, Professor. More coming up. Mike Slater, spread the word. Hey, Slater Crusaders, welcome back to our special high court drama. So my belief is that all of this is about Roe v. Wade, right? Like they'll pretend that it's about other things or whatever. No. It's all Roe v. Wade. And Roe v. Wade over the years has taken on a life of its own. It's a sacred thing, right? You can't touch it. It's private. But what is it? Like how many people have actually read it and know what it's actually based on? Danielle D'Souza Gill is the author of The Choice, The Abortion Divide in America. Go buy this book. It goes through all the myths from the pro-abortion side, and she dispels all of them beautifully. Danielle, how are you?
I'm doing great. Thanks for having me.
Good. Thanks for being here. So I want to focus in on myth 5, I believe, in your book specifically, and we'll get into the legal side of this. So on what constitutional ground is Roe v. Wade decided?
Roe v. Wade was decided in 1973. It was the landmark case that really made abortion a constitutional right. Now, abortion is nowhere mentioned in the Constitution. So they had to go looking elsewhere for this justification for abortion. And they really found it in something they called the right to privacy. Now, the right to privacy itself is also not a right. However, they basically based it on this idea that you cannot be searched in your home, you can't be searched in your car. So they used unreasonable search and seizure. Now, how this resembles abortion is obviously extremely far off. No one is searching women. No one is saying that anyone is doing that, but they had to look for some kind of justification for this. And even Ruth Bader Ginsburg and others have talked about how the foundation of Roe v. Wade was shaky. The justifications used for it were, really not even there. And she actually talked about how they should have based it on other things. So she was in favor of abortion, but she did not see the constitutional grounds for it and how the case was decided.
Oh, that's really interesting. So if I remember correctly, there's some word that the main opinion uses, and it's like, oh, well, we have this Fourth Amendment search and seizure, and this, therefore, privacy is like a shadow, but there's some like weird word that he uses. It's like a shadow of it, and therefore we have a right to privacy, and therefore abortion should be allowed. And it's like, hold on. So I guess the point is, it's pretty well believed, even by pro-abortion people, that this is a pretty shaky argument, no?
Exactly. Yeah, they called it a penumbra, which is basically kind of like...
There it is. See, of course Danielle knew. There you go.
So they knew it wasn't in the Constitution. So that's why they had to kind of invent a way for them to somehow squeeze it in there. And a lot of legal scholars have defended it. And the ones who do talk about the fact that we have a living Constitution. And that's the only reason they could kind of insert this in there, which is the idea that our Constitution is not a static document and all of that. But of course, no one on the other side is saying it is. We're saying that you have to pass an amendment if you want to, say that there's a basis for this in the Constitution. You can do that by passing an amendment, but you need a 2/3 majority, and they obviously didn't have anything close to that. So they had to pull a fast one on us, and that's basically what they did with Roe v. Wade.
How could Roe v. Wade be overturned? On what constitutional basis, or how would that process look? What arguments would need to be made, et cetera?
There are kind of two different paths. One path is the chipping away at Roe. So that would be if the Supreme Court looks at a case that maybe looks at something Clarence Thomas has mentioned, like race discrimination, sex discrimination. He's written about that and how there's a lot of sex-selective abortions, more Black babies than white babies are aborted, and so forth. Sometimes people wait until they can find out the sex of the baby and then choose to abort it. So that's why more baby girls are aborted than baby boys. So obviously there's discrimination going on. So that's one way to chip away at Roe. But if they wanted to actually go to the root of Roe, they would really have to focus on the right to privacy. And basically all they would say is there never was this right to privacy. There never was this penumbra. And that's basically what they did with Brown v. Board of Education and overturning Plessy versus Ferguson. They basically said, no, separate is not equal. Plessy versus Ferguson said that separate is equal. And they said, no, it isn't. So that's basically the way it would go as far as the number. Yeah.
And sorry if I jump in, I like that second approach better, but that's a bigger ask, isn't it? That'd be a big thing to do.
Yes, it absolutely would be. But I think it's been brewing for a really long time, about 50 years. The pro-life movement has really been fighting hard, and we've been so used to losing in the courts. But I like to talk to pro-lifers about, are we ready to win in the courts? Because if we are ready to win in the courts, there's going to be a huge firestorm from the left. They're going to be shrieking, probably throwing blood on the steps of the Supreme Court. I mean, it's going to be much worse than the Handmaid's Tale situation we're seeing right now. So it's going to be big.
Do you know of any cases in the wings that would result in some sort of big, giant overturn like that? Because my understanding is lately the Supreme Court's taken this very specific stance. Like they only focus on the one little issue at hand and don't want to make these big, giant, sweeping changes.
Well, I know there have been various cases that have come up to the Supreme Court and they've said, okay, we're actually going to delay looking at these. And so I think they're actually saving maybe a group of them until they have the majority we need and all of that. So that's why I think in the past, some pro-lifers have said, oh, how come they're not looking at this case? It made it all the way to the Constitution. There was a Louisiana law, a couple different ones, all looking at different aspects of it. Sometimes how wide does the hallway have to be for an abortion? It could be the heartbeat bill. It could be many aspects of it, but they've been saving it. And so I think they're going to do a lethal blow to Roe v. Wade.
Wow, that's amazing. What was the cultural feelings on abortion in 1973? Because I feel like we've made, not only has Roe v. Wade itself taken on a life of its own, but we've sort of made up our own perspective of what the national consensus was or the national belief was at that time too. So what's your understanding of what things looked like in 1973?
Yeah, we're not living in the days of 1973 anymore. Back then, people argued things like, maybe there's potential life in the womb. When does life begin? Those were the questions that they asked. And it really came from this idea that, we don't know for sure there's life in the womb, but we kind of just think that. And that's obviously not the strongest argument. So I think that we've actually strengthened incredibly with technological advances, with the ultrasound, with hearing the heartbeat a few weeks in, with the fact that viability has moved earlier and earlier. Babies can basically spend the whole third trimester outside the womb. So this idea that we don't know what's happening in the womb, I think, is completely gone now. Also, looking back to 1973, in 1972, many states passed laws saying that they didn't want to allow abortion. They passed laws saying that there will be no abortion unless it's a situation of rape or something like that. So what Roe v. Wade did was basically say that all of those laws, all of that consensus from the people is not constitutional. So they said, we won't allow that. If you're a state that wants to limit abortion, you can't. Basically, until kind of the end of the pregnancy. And so it really took away the freedom and the belief that a lot of people had, which was actually quite pro-life.
It was an amazing moment when I first learned that sonogram wasn't a widespread thing until after Roe v. Wade. And you see all these people, including the co-founder of NARAL, who ran the biggest abortion clinic in the country, who once he saw a sonogram, became a pro-life advocate, which is like an amazing reality. Let's do worst case scenario. You're wonderful at speaking about these things in your book, The Choice. Everyone needs to get it. Dianne Feinstein brought this up. She talked about how I lived in a time when abortion was illegal, and I've seen women go to Mexico and women injure themselves and hurt themselves. That's always ultimately the argument that is made, is that we're going to have, if you make abortion illegal, then women are going to use the coat hanger, and more people are going to die, more women are going to die because of it, et cetera. What do you make of that argument?
Yeah, I have a chapter on this because it is so often used by the left. It's actually just a scare tactic. And I do this by looking at the fact that, first of all, number one, as you mentioned, Bernard Nathanson actually lied about the number of back alley abortions. So they had put out these, crazy numbers saying, look at all these women getting back alley abortions before Roe v. Wade. And the reality is that it was actually not that many women who were getting back alley abortions, because why would you subject yourself to that? I think a lot more people turn to adoption and things like that if they did not want that child. But in any case, even if we look at today, there actually are many women doing, quote, back alley abortions as it is. There's a woman called Inga Muscio. She wrote a book on this. She's a radical leftist, and she talks about how the wellness movement and the health movement is basically giving women abortion pills, and they're taking these special teas and doing all this stuff at home and doing these incantations and exercises to abort their child at home. And they actually see the baby come out, and they do this whole weird ritual. So all I'm saying is that it's not like this isn't happening already. And anyone who really wants to do it, like those people who are very confused, are doing it as it is now. So this idea that women are all of a sudden going to be, using a coat hanger, no, they're not going to be using a coat hanger. They're probably going to be turning to these, wellness magazines to get ideas of how to do this. And second of all, this idea that so many women are going to do it, I think, is just completely ridiculous. And we can't stop people from going to other countries, but also, even if they did leave this country to go to another country, we have the most radical abortion laws in the world right now, basically on par with China and North Korea. So if you want a late-term abortion in Europe, you probably can't get one. If you want a late-term abortion in Australia, you probably can't get one, because they don't allow late-term abortion on demand without a medical reason. We do in many states. So we actually could really use some pulling it back.
Yeah, I bet you couldn't even go to Mexico today to get an abortion. I don't even, they probably have more restrictions against it than we do. And even this term, back alley abortion, what an interesting term that they came up with, back alley. Like what are we talking, do you know where that came from, a back alley? What's a back alley?
Yeah, this whole idea that, you meet in a back alley as if you're, I don't even know what you would be doing back there, but no. There's
like no where the dumpsters are, and like, what is that? I've never been in a back alley. It's a funny term, but it's stuck around for all these decades. Really interesting. Okay, we got to go, Danielle, but final thoughts on where you think the pro-life movement is, and then maybe you could take Barrett's stance on all this and what you think she'll do for the court.
Yeah, I think that the pro-life movement is in a strong position. We've never been in such a strong position as we are now because so many more young people are starting to wake up to the fact that this is a human rights issue. This is a human being. There's not just one body, the woman's, but there are two bodies involved. And I think that the fact that so many young people are fighting for this is really inspiring. I think Amy Coney Barrett is a great choice for our Supreme Court. I think the fact that she just answered all of the questions this week with so much calm and so much confidence was really great to see. And I think that if she's on the court, she will serve us really well. And she's not obligated to say how she would respond to a future case of overturning Roe v. Wade. That would be very inappropriate since she can't comment on a future case. So I still have a lot of hope that we could see Roe v. Wade overturned.
Definitely. Get the book, The Choice. It's all how many myths are in there, Danielle?
I think I have about 22.
Yeah, 22 myths, and you've heard them all, and this is the truth behind all of them. The Choice, The Abortion Divided America, Danielle D'Souza Gill. Thanks, Danielle. You're the best. Appreciate you.
Thanks so much. I appreciate it.
We got another segment coming up on high court drama. We'll talk about the history of some of these appointments and going back to Abraham Lincoln. Remember that was brought up with Kamala Harris the other day? So we'll tell the true story of that next. Mike Slater, spread the word. Hey, Slater Crusaders, welcome back to our special high court drama. I want to wrap up here with sort of the precedent that has existed, that does exist, with an election year nominee, right? Everyone's freaking out about how it's an election year, blah, blah, blah. Well, it's happened before, 29 times exactly. Dan McLaughlin is the expert on this. He's the senior writer at National Review, been an attorney for 23 years. Dan, how are you, sir?
Good to be here.
Thank you for being here. So let's start with Kamala Harris. So the other day in the debate, by the way, doesn't that debate feel like it was like 3 years ago? Like was that last week? What in the world? She brought up that Abraham Lincoln story about how Abraham Lincoln did the right thing and waited until after the election. He is honest Abe, after all, Dan, and waited till after the election until the people could decide who they wanted to be president before he nominated his choice. Can you give us the true story on that?
Yeah, and her story is nonsense, and it's particularly nonsense because the way she framed it in the debate was that, Lincoln said this. Lincoln said nothing of the kind. He said nothing at all publicly, in fact, about the nomination. Democrats at the hearings this week have sort of aired the story again. I think Senators Klobuchar and Booker did, but at least they didn't go quite as far out on a limb as Harris did, saying that Lincoln made some sort of grand public statement, which I think was just her flourish. What happened was that Lincoln's arch nemesis, Roger Taney, who was the Chief Justice who had written the Dred Scott decision and who issued a number of decisions that were hostile to the Union's prosecution of the war, died on October 13th of 1864. So it's a few weeks before the 1864 election. Lincoln could not get a justice confirmed before the election. He couldn't because the Senate was out of session. And in those days, it was not so easy to pull back senators from, Wisconsin or somewhere to Washington, D.C. in a couple of weeks. The Senate, when it was out of session, was out for a while. And in fact, Lincoln needed those senators out campaigning for him. And he had another motive for waiting until after the election to pick a replacement for Taney because he hadn't decided who he wanted. And he wanted to dangle the nomination in front of a number of different Republicans, some of whose loyalty to him was very questionable, so they'd all be very incentivized to campaign for Lincoln. Chief among those was Salmon P. Chase, who had been Lincoln's Treasury Secretary. He was one of the founders of the Republican Party. Chase was someone Lincoln could trust completely on the issues. He was very anti-slavery, but he was not somebody Lincoln trusted politically. He had tried, in fact, to steal the nomination from Lincoln, essentially from inside his cabinet. So Lincoln wanted Chase to have every incentive to go out and stump for Lincoln. And after the election, the Senate came back in December, on the 5th of December. The very next day, Lincoln sent up Chase's name to be the new Chief Justice. And he was confirmed that day. There were no hearings in those days. And there was never any indication. I mean, Lincoln said to his private secretary that he had some interest in, hearing from the people, meaning his supporters. to know who he should choose. But he never gave any indication that he was going to allow the seat to be filled by George McClellan if McClellan had beaten him in the election.
So that's another thing too. Like if McClellan won, do you think Lincoln would have been like, okay, I guess we won't even fill this seat in the next few months until the end of my term? Or do you think Lincoln would have gone ahead and just filled it because he was still the president?
I think he would have. I mean, the recent history of this, I mean, Lincoln, first of all, had even argued against following Dred Scott when he was running for the Senate. Republicans in 1860 had essentially run out the clock on James Buchanan filling a Supreme Court seat in the lame duck session in order to make sure that they could fill it. They actually even added a 10th justice, which was in part just because they needed a circuit justice for California, but in 1863. So, the Republicans of his era were they were playing their amount of hardball within the rules to have some control of the court, particularly because the court was issuing rulings that were important to the prosecution of the war. So Lincoln, I don't think there was any reason to think Lincoln would have left this undone for McClellan.
I love knowing that history. That's why history is important. Do you, just take me back if you can for a second, Dan. Was there any chance that Lincoln was going to lose that election at all? Was he worried about that? As of August of 1864, he was very worried that he might lose the election. He was telling his cabinet that he was going to lose the election and that they needed to prepare a transition plan. By October, he was starting to feel better about it. They were starting to get, absentee votes in from the soldiers. They're starting to see, this is after Sherman captures Atlanta, which kind of turns the election. But there was still very much some concern about it. But I think he was feeling a lot better in mid-October than he had in August. Okay. But you mentioned the hearings, and we've seen just, there's been nothing at all. Correct me if I'm wrong. My perspective is there's been nothing noteworthy about these hearings whatsoever. I think you tweeted out the other day or retweeted that picture of Elmo. I'm not going to describe it right here. If someone wants to go to your Twitter and they can see the picture of Elmo choosing the pile of cocaine over healthy fruits and vegetables, being the metaphor of the Democrats choosing to grandstand instead of have any actual substance here. Why do we still have these things? Do we really need to have these things? What do you think?
The hearings there's a lot of pointless show to them. I think they're one of those rituals that even though there's something that, certainly the Supreme Court existed for over a century before there were hearings. And it's only very recently that they've been televised hearings. So it's not strictly necessary to have them. The Constitution doesn't require it. But I think they do still serve a purpose. First of all, if you have a nominee who's just an idiot, that would expose them. And there have still been nominees for the lower courts who really just fell apart badly enough in their hearings that it ended their nomination. So they do still serve a function, but in particular Supreme Court hearings and right in the middle of a campaign, of course, the senators are going to spend a lot of time giving speeches instead of attempting to get information out of the nominees. And the nominees, for good reasons, won't answer the questions that are kind of the most important, which is how are you going to rule on this case or that case? It's unethical for them to do that.
Yeah. Give us another historical precedent to what we're seeing now with the Supreme Court and what we should learn from it.
Well, I think, I think the clear precedent that I've seen from the 29 prior instances is the fact that you have, a very strong line of demarcation. There have been 19 times previously when a president got a chance in an election year or a lame duck session to nominate a justice, and the president's own party controlled the Senate. 17 of the 19 times they got confirmed, and of the two that didn't, one of them was literally because there was a technicality. George Washington nominated one of the authors of the Judiciary Act who would help, write the legislation that created the court, and the Constitution said if you've created a seat on the court as a legislator, you can't fill that seat. So he literally had to wait. And Washington, being humble as he was, admitted that he'd just gotten that wrong and resubmitted the nomination a week later in the new Congress. So there's really only one example, Justice Fortas in 1968, when there was a bipartisan filibuster, the president not getting a nominee through. And, there have been 3 examples of lame duck nominations after a president lost election. The most famous of those is John Adams nominating John Marshall to be Chief Justice. And Marshall is basically the father of American constitutional jurisprudence. And he was one of Adams's midnight judges. Adams had lost the election. The Federalists had lost control of the Senate. But in the lame duck session in December, and you talk about while an election is going on, of course, if you've ever, particularly for those who have watched the John Adams miniseries or seen Hamilton, that election dragged on well after Election Day because the House of Representatives was fighting over whether to seat Jefferson or Burr. Well, all of that was still unsettled in Congress while Adams sent up Marshall's nomination to the Supreme Court, and he was confirmed by the lame duck Federalist Senate.
Wow. So I give no credence to the argument that you hear from the left now, which is like, oh, we're in an election, because you can't ever draw that line. Like, when are you too close to the election where you shouldn't nominate or appoint someone? But I could almost...
The reason why why we talk about that line is because of the other side of that precedent, which is that when the Senate is from the opposing party, traditionally they have stopped presidents in an election year. And the fact that it's election year, it's not that it's improper for a president to send up a nominee, right? Because every single time a president has sent up a nominee. The reason is that the Senate can legitimately say, look, the voters picked you to run one branch. They picked us to run the other branch. We can keep the seat open for a couple of months and let the voters break the deadlock. That's all it comes down to. That's what happened in 2016.
Yeah, and yes, amen. And I could almost, though, see the argument in that Adams story where it's like, oh, you guys did lose the election. You lost the Senate. You lost the White House. You shouldn't do this. But even then, the term is still 4 years. So I think they're still in the right. Do you know off the top of your head the other 2 circumstances that was? I mean, that was Adams, and then who else?
Yeah, one of them, I believe, was Martin Van Buren, and frankly, Van Buren and Jackson, in the 1830s, were again very, very concerned with turning the court after Marshall, at the end of Marshall's tenure and after his death. And Van Buren had just lost, so it was the first ever election won by the Whig Party. So the Democrats all of a sudden had lost control, and they wanted to make sure they got another justice in. And the other one was Benjamin Harrison in 1892, who actually, Harrison, you talk about a guy who maximized the power of the presidency and the power of the Senate. Harrison had won the presidency in 1888 despite losing the popular vote. And he put 4 justices on the court in 4 years, including one in July of 1892 in the middle of the election, and then another one in, I think, December, or maybe it was in February of the lame duck session after he had lost. Harrison used the powers of the presidency, and because the Senate was from his party, they went along.
So it'd be like if Stephen Breyer passed away in 30 days and Trump and the Republicans knocked through one more justice.
Yeah, that would be pretty controversial, obviously, as all these things are. But history would be on his side if he did that.
Whoa, amazing. Dan McLaughlin, please follow Dan on Twitter. His handle is Baseball Crank. When did you come up with that Twitter handle? I reckon years ago?
Yeah, it goes a long way back. I actually started blogging under the name Baseball Crank in 2000. Back in the early days of the blogosphere, and it has a historical significance because cranks is what they used to call baseball fans in the 19th century.
Oh, well, there you go. Look at that. And you're a history buff, clearly. Baseball Crank, senior writer, National Review, Dan McLaughlin. Dan, superb. Thank you, sir.
Thanks.
Love that. I love the history. Getting historical perspective brings me so much peace. All right, that's our special High Court drama. See you on Monday. Spread the word.